Hello, and welcome everybody to the first in our series of launch events for our new series on alternative regulatory responses to misinformation. My name is Michael Karen-Nicholas, and I am the Wikimedia Fellow at Yale ISP, where I run the Initiative on Intermediaries and Information. I will note at the outset that this meeting is being recorded to be posted to our website after the fact. So if you participate by asking a question, or if you turn your webcam on, you may appear in that broadcast. However, we very much encourage you to ask questions when we get to the Q&A point towards the end. I'll just take a moment to sort of introduce the series at the outset and our intentions in putting this out. The purpose of this series is to spur novel or outside the box thinking in terms of regulatory responses to misinformation. That should be really understood as part of a response to a recent trend of governments passing new restrictions or stepping up enforcement of existing criminal law restrictions targeting fake news laws. These fake news laws have been particularly prevalent across Africa, but they're not limited to the developing world. There's been new laws passed in Canada, in France, in Germany, and they're extremely problematic from a human rights perspective insofar as these laws are routinely abused and used to target journalists, opposition figures, civil society, anti-corruption watchdogs, anybody that would put forward a narrative which might run counter to official government understandings of the way that things are. And so, we see this trend of problematic laws that are criminalizing the spread of misinformation, often as defined in an overly broad way. And these laws are problematic. However, at the kernel of this issue, there is a real problem. And the COVID crisis, in a lot of ways, has helped to crystallize the potential harms flowing from misinformation. And so as a result of that, and as a result of, I think, a well-established need for a proper response to misinformation, and ideally one which doesn't rely on criminal content restrictions, we've developed this series, the purpose of which was to provide space for conceptual development of novel or under-researched regulatory responses. So we have 5 papers that are included in the series, each of which approaches this issue from a completely different issue and a different perspective. The authors retained their own editorial control over their ideas, but we tried to support them through a number of rounds of editing, commenting, and review. And I'll pause here to give a quick thanks to our student team of Abby Lemaire, Elizabeth Zeitz, Juan Carlos Salamanca Vasquez, and Robin Ascari, all of whom were enormously helpful in our editorial process. And I will also pause to put a quick link into the chat for the full paper series for anyone who wants to access that. So without further ado, we have a wonderful panel today to begin the discussion, including 2 of the authors from our white paper series and 2 commenters. Ivar Hartmann is an associate professor at Insper Learning Institution in Sao Paulo, Brazil. His research and teaching areas are cyber law, constitutional law, and legal data science. He was previously an assistant and associate professor at FGV Law School in Rio de Janeiro, where he coordinated the Center for Technology and Society and the Legal Data Science Nucleus, and taught an innovative course called Programming for Lawyers Yearly from 2014 to 2020. Ivar holds an MSc from the Catholic University in Rio Grande do Sul, Brazil, an LLM from Harvard Law School, and an SJD from the Rio de Janeiro State University. Akriti Gaur is a lawyer and independent researcher studying digital platforms and their impact on human rights in India and South Asia. She has previously worked on research and advisory projects related to privacy and data governance and rights-based approaches to govern emerging technologies in India. She will be joining the Yale Law community this fall as an LLM candidate. Dr. Barbora Bukovská is a Senior Director for Law and Policy at Article 19, Global Campaign for Free Expression and International Freedom of Expression Organization. She leads the development of Article 19 policies, including those related to digital technologies, and provides legal oversight across the organization, a position she has held since 2009. Barbora has extensive experience working with various organizations on a range of human rights issues, including protection from discrimination, access to justice, deprivation of liberty, reproductive rights, and community development. And Artur Pericles Lima Monteiro is Head of Research on Freedom of Expression at InternetLab, a Brazilian independent research center on law and technology founded in 2014. He's also a visiting fellow with the Information Society Project at Yale Law School, and he holds a master's degree and is a doctoral candidate at the University of Sao Paulo. So I am enormously excited for today's discussion. And I think we'll start off with Ivar to give a quick presentation of his work, followed by Akriti, and then followed by the two commenters. And if at any point, but we're going to have some time for discussion and question and answer afterwards. If folks want to put questions into the chat, that would be very welcome. Or you can also raise your hands at any point to start a queue, and we will have a time for discussion and back and forth towards the end. So Ivar, without further ado, I'm looking forward to your presentation.
Thank you very much, Michael. I'm very excited to be a part of this paper series. I'd like to thank Yale ISP and Wikimedia Foundation for organizing this, and I'd like to especially thank Michael for his skilled and generous work editing my paper and helping making it the best possible version that it could be for this series. So my proposal involves ad libraries and fact-checking, and it's the same as all of the 5 papers in the series. This proposal tries to address misinformation, but in this case, it's the combination of a very, very specific type of misinformation with another problem. So these are 2 problems combined. One is exploitative misinformation. So it's not about misinformation or fake news for political gain. It's not about fake news for the lulz. It's about fake news and misinformation for profit on the one hand. On the other hand, so the other problem that is combined is programmatic advertising. So this is the fact that increasingly large share of ad revenue is put into social media companies and platforms in a way that is much different from advertising done 30 years ago. So programmatic advertising means that the advertisers no longer have full control of the decisions of where to advertise and how to use their money. It means that advertising is no longer focused on the location in terms of placement, not the venue, not the outlet where that ad is going to appear. Rather, it is focused on an audience, and then it doesn't really matter if that audience is reached. It doesn't really matter where this ad is going to appear. And lastly, it's very different from what we had 30 years ago in the sense that these choices of placement are obscure. So they're pretty much impossible to understand or have the public in general has no idea who these ads are being shown to. And even the advertisers themselves do not, as I said before, not only they don't have full control of where these ads are running, but they also, more often than not, don't even have knowledge after the fact of where those ads actually appeared. So this is a combination of these 2 problems: programmatic advertising on the one hand, exploitative misinformation on the other hand. Now, a first response to this combination of problems came in 2018 when Google, Facebook, and Twitter created something called an ad library. So basically, they put up lists or transparency reports, if you will, of which ads were being bought, where they were running, for how much they were, what was the money that they were being bought for, and some data on what the audience was for these ads. Now, this initial version was improved, fortunately, but as they stand today, ad libraries, even 3 years later, they still have severe problems in trying to address this combination of programmatic advertising and exploitative misinformation. So first, a problem of access. Bulk access is not usually allowed by these ad library platforms. So researchers, for instance, in academia, they can't just download all of the data that they need. Some of these ad libraries are riddled with bugs, which also hinder access. Not all of the variables that would be necessary to give some kind of transparency to these ads are available. Sometimes they are for some of these, for a few of these companies, but not for all of them. But more importantly, there's an immense problem of scope in terms of what ads are part of these libraries. And in 2018, the main idea was that ads that should receive this increased amount of transparency were ads related to elections. So these were ads that the companies deemed to be political, ads that were related to political issues, ads that were paid for and run by political figures such as parties, political candidates. And one lesson that I think we have all learned in 2018 regarding misinformation is that it's not only misinformation about or during elections that has the potential to harm societies. So misinformation regarding health policies is also a huge problem. It doesn't have anything to do with elections. So this problem of scope, where platforms have decided to themselves pick what are the ads that should receive transparency based on this very hard to work with concept of political ads, that is the main problem that I try to address in my proposal. So platforms, in essence, they don't have the legitimacy to decide what are the ads that should receive this increased amount of transparency. Furthermore, they have no digital platforms such as Facebook, Twitter, Google, they have no journalistic expertise to identify misinformation. And especially to make decisions on wide categories of misinformation. And lastly, there's a big conflict of interest regarding which ads should receive increased transparency, because as many authors in the literature regarding ad libraries and programmatic advertising point out, there's a big conflict of interest in the sense that exploitative misinformation actually means more revenue, revenue for these digital platforms. So the proposal is that either platforms voluntarily take this on, or they are legally mandated to publish ad libraries that allow anyone to download the bulk data, which is not something that all ad libraries allow today. So one important feature has to do with access. Another important feature has to do with the variables or the data about each ad. So not all digital platforms today allow transparency on what the targeted audience was. And more importantly, regarding that problem of scope, the proposal is that platforms do not give increased transparency in these ad libraries to any type of ad that they deem to be political. Rather, they create a version of this ad library. And this does not mean that they would have to remove anything from the current ad libraries, but they have to create a separate version that is already filtered for civil society, where they cross-reference the content that has been fact-checked by one or many of the very numerous fact-checking agencies that we have today worldwide. So they cross-reference fact-check content with the advertised content, and they create a separate ad library, which is the scope of which is fact-checked advertised content. So that, in essence, is the proposal. This was, of course, a very short version of the proposal, so I had to oversimplify a few things. But of course, the paper is already available for everyone to read, and I'm very much looking forward to the discussion.
Yeah, thank you so much for that. It strikes me that platform and algorithmic transparency is, in addition to the misinformation component, there's so many broader discussions going on right now about platform and algorithmic transparency. And lots of people talking about the need for transparency in this space, but still a dearth of specific concrete proposals. So I think that it's an important contribution from that perspective as well. And certainly with the focus on user empowerment, that's very welcome. And I think a common theme to our next presenter as well, Akriti, who's going to be discussing her own paper on these issues.
Thanks, Michael. Hi, everyone. I'm very excited to be here and to be talking about the paper, and very much look forward to the discussion. Before I begin, I'd really like to thank the Yale ISP community and the Yale ISP fellows for providing very critical feedback to my paper over the past couple of months, and especially thank you to Michael for your patient edits and helping me through sort of working with these ideas. So thanks a lot. Before I sort of proceed with my model, which is essentially to suggest alternative approaches to platform regulation, which is a shift from traditional legal and regulatory models to self-regulation, to sort of bolstering regulatory capacity of countries like India, and prodding platforms to work closer with communities. And I'll explain these models in slightly more detail. But all of this is happening in the context of evolving and chaotic internet regulation in India. I mean, as we speak, 10 days ago, the Indian government notified amendments to the intermediary liability regime. So India provides a safe harbor to all intermediaries, including big tech platforms. And these amendments seek to regulate them further. And while they, some may call them well-intentioned because, there are some due diligence provisions for social media intermediaries, these definitions are fairly vague. The regulations are extremely broad-brushed because they're also applicable to cyber cafes and search engines, which are all defined in a chunk of intermediaries in the Indian law. At the same time, these regulations set out some obligations for takedown of content based on very vague criteria. All of these factors together, of course, threaten free speech of users on these platforms, and also end-to-end encryption, and come with a host of privacy issues. I want to say this because traditional regulation, in my opinion, in India and many countries across the world is running its course. I mean, it's been stretched far too thin to adapt to evolving platform harms. And now it's coming at a cost of, offending citizen rights, and also, at a cost of free speech and privacy on the internet, which is what brings me to two models that I propose today, which is bolstering regulatory capacity of the Indian government and civil society and platforms by induced self-regulation and the creation of an independent platform oversight body. And the second one is to sort of prod platforms to work with local communities through groups such as hyperlocal platform communities. Now, I think to put the misinformation problem also in context, it's important to recognize that both the government and the platforms like WhatsApp, Facebook, Twitter have just not done enough to really address the fake news problem. Indian laws right now are fragmented. They do not truly, aim to address the fake news problem from the root. We have several ministries, including the Ministry of Information and Electronics and IT, which is the nodal ministry, as well as 6 other ministries, which often come with inconsistent orders for, blocking accounts and banning journalists, etc. And on the other hand, we have platforms with, unilateral self-regulation, which has largely failed. And I'll give you the example of the Information Trust Alliance, which is a self-regulatory body being proposed in India, which potentially would consist of platforms, civil society, academics, experts, etc. But little is known about its functioning, and there's not much consensus. So on their own, also platforms have failed to self-regulate. And which is why one of the first things I talk about in the paper is induced self-regulation, which at its very core means the creation of an enabling regulatory environment, which induces and it spurs platforms to create regulation which is accountable and transparent, and at the same time retain independence and have the flexibility to define their regulatory objectives. Now, there has been international push, and in terms of evolving models for induced self-regulation. Some of you may be aware of the EU Code on Disinformation, which sort of seeks to get some platforms together to build a common code of conduct around disinformation. Of course, it has certain gaps in terms of the fact that it's very difficult to measure the performance of platforms, or some of the information is not available to researchers. But in this paper, I essentially talk about how some of these models can be developed further for the Indian context. And in doing so, some of the sort of immediate next steps for setting up induced regulation or regulated self-regulation in that context would be to start something with collaboration among government, platforms, civil society, and experts, which need not be immediately hard-coded in legislation. It can take the form of private and public initiatives. And at the same time, it is hoped, and I talk about this, is how this induced self-regulation can create necessary regulatory or market incentives for platforms to act on these factors. And some of the objectives of induced self-regulation in this context to fight misinformation can be user empowerment, grievance redressal, or implementing design duties to address the fake news problem, which I don't know if it's surprising anymore, but WhatsApp has taken several measures in India to restrict mass circulation of fake messages, to help users access fact-checking accounts. But all of these are voluntary. They've not worked, and you'll find a lot of criticism of some of these design features, which are often gamed by political parties and bad actors. So it is hoped that with sufficient collaboration, platforms and government can work together. Which brings me to the next part of my model, which is the creation of an independent platform oversight body. Now, the reason I say this is the nodal ministry, which is the Ministry of Electronics and IT in India, has failed in its objective to sufficiently regulate or meaningfully regulate intermediaries and evolving platform harms. There's also a lot of fragmentation in lawmaking. There's a lot of opacity in lawmaking. There's not adequate consultation of experts, stakeholders, and even platforms. It's hoped that specifically to combat misinformation and for issue-specific misinformation, a platform oversight body can sort of bring everyone together and work towards combating it through setting up effective standards or using soft compliance measures, some of which I've explored in the paper. I also try to sort of study international models on creating an independent platform oversight body, which have been suggested by several scholars and experts across the world, and sort of put it in context in the Indian regulatory sphere. Because in India, as of now, I've not found a model which would be suitably at an arm's length from platforms in the government. But in this model, I try to propose exactly that and how that can we can go ahead with it. And lastly, I talk about how so these are the chunk of solutions which the government can implement or civil society can implement with the platforms. But platforms on their own also need to work with local communities and understand sort of the speech context or the contextual aspects of misinformation that they're working with. And in this context, as in there's been a lot of discussion about how platforms are very top-down in their approach to platform policies, to content moderation decisions. And given that India is a country which 23 official languages spread across 29 states, millions of users online, there is a need for platforms to really work from the bottom up and rather than the top down. There is a need to suitably externalize some decision makings and even standard setting, because most of these are predominantly set out in, let's say, the United States and now are being gradually applied and modified. That approach, as I argue in this paper, will not be very sustainable, and which is why I also propose sort of two things which can happen here, right? We can create voluntary misinformation groups at a sufficiently decentralized level for issue-specific misinformation and acute harms from misinformation, which I've outlined in the paper, and also create hyperlocal platform communities. And in this, there's been a lot of discussion on social media councils, and the Article 19 consultation paper talks about evolving models of social media councils, which can work with local communities, governments, policymakers to set out speech standards from the get-go. I've also discussed some of the sort of work which is being, or some of the commentaries which have been made by independent groups studying Facebook, for example, the DTAG, which is the Data Transparency and Advisory Group, which talks about the need for a bottom-up approach to rulemaking. And sort of, again, putting all of this in perspective to see how they can be implemented in India, I provide some solutions to implement this in the regional and hyperlocal levels in India.
Thank you so much for that presentation. Yeah, it's a very it is extremely important to break out of a lot of the policy conversations are certainly still as they take place in the US, and even as they take place among the platforms themselves, are still overly US focused. So it is very valuable to break out and to consider ways to broaden impact, and certainly the idea of localizing content moderation standards, I think, is a very valuable one. And I think that there's very valuable contributions from this work. We're going to get a couple of comments now. First from Art on these papers, or some of the broad ideas that are raised. Art, do you want to go ahead?
Sure. Thank you, Michael, and thank you, Akriti and Ivar, for your informative work. I appreciate the opportunity to discuss this important initiative. I think it calls on us to move the conversation on misinformation away from the usual suspects and to broaden our perspective in responding to this issue. Now, I get to offer some comments on Ivar's paper, which proposes mandating transparency around ad libraries for the likes of Facebook and Google. Now, I know the goal of the series here is pragmatic, but I must start by how much as a scholar I learned from reading the white paper. It's quite richly cited, spanning from research on the disciplines of marketing and advertising, as well as communication studies, rarely a source we see in this kind of work, to other policy proposals and initiatives around the world, to intricacies on how platforms currently structure their ad libraries. The paper is clearly the result of careful, long reflection on the literature on disinformation and builds on a body of work by Ivar. He's quite familiar with questions and methods for the kind of research that is entailed by ad libraries, and the paper shows this. I think a crucial part of responding to the challenge of misinformation is understanding the complex ecosystem of actors, audiences, and platforms, and how this impacts the institutions we as a society have relied on for maintaining a healthy public sphere. The paper leverages those interactions in making the proposal. Ivar isn't offering a silver bullet to stop all fake news. His recommendation focuses on providing the tools so that activists, advertisers, and fact checkers can act. This is an exercise in building or fixing institutions, so Ivar expects results to follow over time, not necessarily overnight. Ivar connects research on the operation of the so-called fake news websites, a notorious example of which was reported in the media after a journalistic investigation on the operation of a fake news cluster in Macedonia. The white paper shows how operations like that are only made possible by a loophole in how digital advertising is structured, with brands outsourcing the placement of ads, with results that are neither in the interest of citizens nor of advertisers. The way I see it, the proposal isn't so much about curtailing any one party from seeking to further their goals. Rather, Ivar offers a fix, so that brands, platforms, and activists can better serve their respective interests, which the white paper expects can be realigned away from the schemes that make fake news websites possible. I think the proposal is insightful and promising, and does an excellent job as showing how the conversation around misinformation connects to the ongoing debate about researcher access to data. As I said, I learned a lot from it, so it got me thinking around some questions. I'd be curious to hear from Ivar. I'm going to throw them out there. There are 6 of them. And Ivar, feel free to take the ones you think make sense, particularly considering the time we have. The first question is, the proposal is smartly tailored to address fake news websites or more generally profit-motivated disinformation actors. To what extent do you believe the proposal will make a dent on the overall phenomenon or phenomena of disinformation? I mean, if all goes according to plan, how much do we expect to see healthier digital environments? Second point, you stress, and I think this is a key contribution from the paper, how micro-targeting is an important driver in for-profit motivated disinformation. The question is, might mechanisms you describe operate similarly, even if we moved away from micro-targeting, from ads based on troves of user personal data to context-based ads? My third question, in terms of the selection of fact checkers, the white paper suggests starting from the work by the International Fact-Checking Network. We know they have done important work in setting standards for fact checkers, yet many on the right, including some prominent officials in Brazil, for instance, have been slinging accusations of bias in who counts as a fact checker. Given matching fact checks will be part of the mandate you put forward, what do you make of this? Is there a way to avoid litigating who officially, according to the government, counts as a fact checker? For instance, establishing an open API and interoperable standards so that any fact checker can, in theory, work with the InternetLab libraries, while reserving to the advertisers the question of who they'll include in their assessments. Our fourth question, Facebook provides, and you mentioned this, Facebook provides different data in its ad library for political and social issues as opposed to other ads. Do you think platforms might have legitimate business reasons not to disclose complete records for all ads? Might there be collateral implications in commercial advertisers having access to that kind of data in terms of competition, user nudging, manipulation, etc.? My fifth question is, how do you see the proposal impacting the agenda on access to research data? You note companies have resisted and even gone as far as to threaten litigation against researchers designing systems to extract data companies would not wish to disclose. Would this proposal be seen as setting the limits on what researchers can access? Could companies use the fact that there's one government-mandated transparency mechanism to argue anything beyond that has no support in law? And now my last question. In Brazil, at least, there's an ongoing debate about programmatic ads bought by the federal government and connection to fake news websites supporting the Bolsonaro administration. Do you see a role for the proposal for this kind of issue? Or would you go further for government bought ads? Now, those are the proposals I was curious to get your perspective on. Again, I don't think we'll have time to go over each of them. So I just hope some of them will be a good way to hear more from your experience and expertise in working with this issue. It's a great paper and opens the door for us to explore so much more. Thank you.
So those are all excellent questions. Thank you so much, Art. Well, I think Ivar will need a minute to prepare his responses to those. So we'll go over to Dr. Bukovská to discuss these issues as well.
I need to unmute myself. Okay, hello everyone. So I'm Barbora from Article 19, and thank you so much, Michael, and everybody else for inviting me and Article 19 to this very interesting and insightful conversation. And also thank you much for sharing the papers, and congratulations on the publications, which in many ways reflects the ways Article 19 has been thinking about these issues for over the last few years. And also I'm glad to see the embracing of some of our recommendations in the paper, especially in Akriti's paper. So what I'm gonna do in my comments, I'm just gonna offer some overall comments about the issue in hand, and also I was asked to comment on social media regulation system or independent self-regulation aspect of the discussion, Akriti's paper. But from the outset, I would like to start with pointing out that Article 19 recommendations in this case, and this is also would be my recommendation for the papers, is that the focus is way too much on disinformation in isolation, and pointing out to the fact that under international human rights law, falsity of the information is not a legitimate interest for restricting freedom of expression. And it's always needs to be linked to the specific harm that disinformation causes, and specifically connected to legitimate interests, which are clearly enumerated in international human rights law. So not focus on the fact that certain information or certain data or certain article or content shared is false, but to link it specifically to the harm. So that's kind of a shortcoming of the paper, which seems to be talking about misinformation, disinformation in isolation, and not to link it to other legitimate interests. So for this reason, whatever Article 19 proposals in this field are, we are not looking at the specific content, but rather in creating institutions which can empower users and address underlying issues, which we are, why we are in this problem and why we are talking about disinformation. So here the problems are obviously a business model of the companies, the overall context of this profit-driven business model, which is not conducive to diversity and which prefers and preferentiates the information which has potential to get viral, which induces clickbites, and then also the monetization of this user's behavior. So that's number one. Number two is to respond to the problems in the content moderation and curation practices, which are opaque, which are inconsistent, and also based on, to a certain extent, unknown criteria. And then also on the dominant position of few digital companies, a handful of companies, which have a dominant position on the market or even super dominant position on the market. So that are the drivers for our proposal, not the fact that there is a disinformation on the platform or even other problematic content on the platform. So, and Article 19 is not alone in these recommendations, and these concerns obviously have been reflected elsewhere, but I just want to make sure that this we keep in mind when we talk about this topic and reflect them in your papers. And Akriti already mentioned one of the recommendations, and we very much appreciate the focus on this issue in India, how the self-regulation could work better in the system, including addressing disinformation. So I just want to mention a little bit more in detail what this model contains, and also I would like to see how would Akriti respond to those questions, which we are still struggling. So it was already mentioned that we put forward the proposal of the social media councils, which at the time in 2018, when we came up with this idea, we call it independent self-regulation. Obviously, it's oxymoron because you can't have independent self-regulation and you are either independent or self-regulatory. So since then, we have started calling this model multi-stakeholder regulation. It's a handful, so we need to come up with a better terminology than independent multi-stakeholder regulation, but it's basically a learning from the history of broadcasting and press councils in different parts of the world and creating a similar system or be inspired by the system for the social media. So, and this idea gathered significant steam in recent years. Our UN Special Rapporteur of Freedom of Expression in his report 2 years ago really liked this idea, endorsed it, and has been endorsed since by a number of civil society communities. And we are proceeding with this model, setting it in Ireland, or leading discussions in Ireland. And this model would be creating a sort of network of national or regional social media councils, which would be providing some general guidance to social media platforms and also deciding on individuals' complaints. Our idea is that they would apply international human rights standards either directly or on the basis of the code of principles, which would be adopted globally. We also think that it's very much necessary that they would have adjudicatory function. So they would be deciding about individual complaints of the users. Users could be able to bring a complaint through some sort of a platform system, and then the platform would have a full control over the case docket and would filter the cases which they would be reviewing on their own criteria. We also, as was already mentioned, published the consultations on this issue, which focus on issue of constitution process, structure, then geographical jurisdictions, should it be national versus international, the rules of procedure and funding. So I would like to, in the process of discussing these issues, we have struggled with certain questions. So I would like Akriti to also look at this, these questions, or tell me what she thinks about those issues, whether how she would square the Indian National Self-Regulation or Social Media Council, if we call it that way, with some geographical issues in terms of jurisdiction beyond the content which is coming from India, but also users in India can access. So whether you would want to have it linked to some sort of international system of cooperation, then how they should be deciding this individual cases versus deciding on the policies, because very much when we talk about content regulation, including disinformation, the issue is not just individual cases, but also the policies and the community guidelines which the social media set for themselves, and then how they are implied in practice. So how would you envision the system operate in terms of individual complaints and individual cases, especially if it's a lot of cases of similar issues? Then the issue of who sits on the social media councils or self-regulatory system has been always very contentious, even when we talk about press councils or broadcast councils, broadcast media regulatory bodies. So what will be the constitution process for India, and how to make sure that different views from different communities, especially from those that are disempowered, would be sufficiently heard? And then also specifically funding, because we have some ideas on the funding, how this would work, and we think that this should be the companies that should be contributing to the operation of the model, not the taxpayers. And they shouldn't be asking, they shouldn't be asked to create a system and pay for the system where the companies benefit from the users' data. So in terms of funding, how you would envision this, but then also how you see this model, let's say, complementary to other systems, because I think that social media and self-regulatory system will not really resolve many other issues which we deal with when we talk about the content moderation and curation, especially this dominant position of few social media companies. And then even if we invite others, because who is dominant is a question, but the dominant position of the platforms should really be targeted first, which is not going to be resolved by this system. So we have some ideas. For example, we are talking about some pro-competition remedies, such as unbundling. We have a proposal for unbundling the services which the social media companies are using, and separating content curation, content moderation, and hosting. So how would you see this this model which you are proposing to sit in the context of other necessary regulatory measures in this area? And I'm happy to discuss some of these issues further in the discussion or later.
Yeah, thank you so much for that. So many of those questions that you raised, the jurisdictional questions, the independence questions, the funding questions, really cuts to the heart of the conceptual challenges there. I'll just briefly say that I quite take your point with regard to the need to tie regulatory responses to specific harms where these responses restrict freedom of expression. I'm in complete agreement to that. I will note, though, that part of the purpose of this series was to try to move beyond those restrictive measures, which is one of the reasons why it's framed as broadly as it is with regards to integrity and veracity in the discourse, which is obviously a broader issue. You know, but we also do in the introduction reference back to the international human rights standards as I think they have currently developed, or at least the jurisprudential standards. But I do quite take your point that the definitional and framing on that front probably could have been clearer. And it's kind of always a challenge when you're tying together these different papers to sort of ground them all together alongside a core framing. But certainly I'm in absolute agreement on the international human rights standards with regard to misinformation laws. So we're going to open it up to a Q&A. I'm going to start by giving our two authors a chance to respond to these very insightful questions that have been asked of them. And in the meantime, if folks want to start raising their hands or enter any questions in the chat, we will get to those as well after this discussion. Ivar, do you want to go first with some responses to all those wonderful questions that are raised?
Yes, they were indeed wonderful questions. Thank you, Art. This was a very thoughtful and insightful reading, and the comments as well. And I'm not going to underestimate the level of complexity and sophistication in your questions by trying to address all 6 of them. And also that would rob us of more time for other people who ask questions. So I'm gonna try and address mainly 3, 4, and 5. So regarding the possibility of some kind of litigation, or even if it doesn't reach courts, but just the idea that if some kind of government regulation decides what are the fact-checking agencies that are going to count for these new proposed ad libraries as the source for the fact checks, and then some institutions might question the choice of fact-checking agencies. I agree with you that this is a concern. This is something that I thought about, and I think this was underlying in some of the back and forth that Michael and I had while he was reviewing the paper. Basically, I think the more concrete decision on what fact-checking agencies will serve as the source for this new ad library, this decision should not be enshrined in legislation. I think there should be something in legislation just determining the overall framework of these ad libraries as they are mandated, if they are mandated by law. And then an independent governmental agency would make the more specific decision of which fact-checking agencies, or rather which group, which international accreditation association is used, at least for a certain period of time. So I think that more concrete decisions should be left for an autonomous governmental agency instead of something that is being enshrined in law. This does not mean that it would not be subject to criticism, of course, but the fact that I acknowledge that it might be subject to criticism is the reason why it should be a decision that is easier to change and that is more flexible in terms of improvement, so that it can be reviewed every year, for instance, because I assume that there is going to be some level of criticism. Regarding number 4, so I think, and maybe this was implied in your question, and if so, I agree that there are legitimate reasons for some of the information about some of the ads that Facebook and Google and Twitter run not be subject to increased transparency. So I think there are legitimate reasons. There are reasons why companies would like to keep information about their marketing strategies secret, especially from their competitors. And I think if there's not some kind of indication of wrongdoing, I don't see why there should be mandated transparency, increased transparency of the type that I'm advocating for in the paper, in the proposal, I don't think that this should be too broad. And that's why while Facebook right now actually includes all of the ads in its ad library, I do not propose that we just take all of the ads and then increase the transparency about them, rather that we select the more specific ones that have an indication that they are fake news, or that they have some level of misinformation involved, and those would be subject, and strictly those would be subject to increased transparency. And then fifth, regarding the research, so this is a big problem, and I think one that we as researchers in academia are especially aware of, right? The limitations, the severe limitations that researchers face when trying to gather information about the actual practices of these digital platforms, that gather raw data, actual data. And I think there's Thomas Kadri has an excellent paper about this that I cited on the proposal. And I think that if we did have this type of ad library as envisaged in the proposal, it would be a big help, at least for those who are studying misinformation and fake news. So that is another facet of the problem that I am also concerned with. And I think I agree with you that this shouldn't be overlooked. And my hope is that it would be to some extent addressed. Yeah. So I'm just gonna, those are my reactions, not proper responses, but my reactions to three of the six very insightful, generous questions that you asked, and we'll keep in touch, and I'll try to continue thinking about the other three. Thank you.
And we'll over to Akriti for her follow-up.
Thank you so much, Dr. Bukovská, for your insightful comments on this model. And some of these questions are extremely relevant to be, thinking about from an Indian perspective. So I really appreciate, your comments and your explanation of the social media councils and how sort of Article 19 has viewed this procedure. So at the outset, as in just to sort of also give a little bit of an idea of what I've been thinking about with the hyperlocal and regional platform communities. I think in the paper also I've sort of tried to explain the fact that India is not ready for induced self-regulation of this nature. And there's so many jurisdictions across the world which would be struggling with this. So to be setting up an idealistic representative body which works from the ground up is going to have a lot of challenges. And you've very rightly pointed out some of those challenges, and in terms of setting it up, in terms of it sort of being implemented perfectly, which is why I feel like, to begin with, what I've tried to do and to sort of address some of these questions is talk about a platform, a hyperlocal platform community, which works with very specific hyperlocal speech challenges when it comes to misinformation. So in the paper, recognizing these challenges, I've tried to differentiate its functioning from other bodies, let's say the Facebook Oversight Board, which works on post-facto content moderation. So what I've tried to do is create that distinction. And as you, sort of one of your questions was whether, this would be deciding on cases or rather setting standards on policies. To begin with, I've suggested a model where this body will be working on the latter, which is to develop speech policies, not so much the content decisions, not so much decide what's acceptable forms of speech or not, but only from the very specific lens of misinformation, work with platforms, work with communities to help them identify local speech challenges, to help them identify and audit guidelines, which could be, the terms of service, the community guidelines, the enforcement guidelines, and work with local areas or regions or states or cities in India to gain more inputs on what misinformation contexts really mean. And just to give you an example, sort of explain the thinking behind this. And Chinmay Arun also talks about hyperlocal speech challenges in India, where she essentially talks about how caste is such a unique, identity sort of factor in India, which, platforms and platform decision makers are often not very cognizant of. Or a word which, may mean something in one language may not mean anything in the other. In some urban areas, triggers to fake news may be consumption of beef. In some rural areas, that rumor might lead to sort of communal violence. In some other urban areas or rural areas, misinformation, priorities might be completely different. So my motivation to suggest a hyperlocal platform community was to actually just work with local communities and help platforms, which are sort of not sufficiently decentralized in their decision making right now on speech policies, to sort of help them do that. And I think you raised a very important point of, who will sit on these councils and, communities. So so one of the things that I've proposed for a hyperlocal platform community, as I see it happening in India, is that it would be set up at either at a state level or a regional level, or at a larger city, urban or local center level, which could consist of the residents of that area, civil society, experts for issue-specific aspects of misinformation. So whether it's electoral misinformation, financial fraud, there could be a possibility of subject matter experts, academics, and of course state actors also to be a part of that group. Now, one inspiration I think is from one of the discussions from the Facebook Data Transparency and Advisory Group, which talks about nested communities, which can help platforms sort of build ground up approaches, which would be similar to an elected parliament. So one of the ways in which a hyperlocal platform community can be set up at a local level could be through a more democratic process of selection of people to ensure that there is sort of independent, collaborative, and an unbiased representation on these platforms. You also sort of mentioned funding. To be very honest, funding is not something that I've explored in a lot of detail in this paper, and it continues to be one of the challenges that I'll be thinking about. So thank you so much for pointing that out as well. You also mentioned how bodies like this can, whether they would be working extremely in an isolated way in the domestic capacity, or whether it would involve international cooperation. I'm not very hopeful about these bodies functioning very well in silos. So as you suggested, at some point where we are clear on the questions of independence, elections, financing, and functioning, these bodies can be scaled, and there can be an international agreement on how these bodies might function in each and every country. So that's fairly open-ended for me at this point, but very grateful for some of your comments and questions, and I'll be thinking about these in more detail as well.
So we have a hand up in the queue, and there's also a question in the chat. Why don't we go to Mark if you have a question first, and then we'll get to the question in the chat, because I think folks will want to weigh in on that one as well.
Hi, thank you very much. Can you hear me?
Yes.
Okay, great. My name is Dr. Mark Leiser. I am a law professor at Leiden University in the Netherlands. I only received the paper today, so apologies for not having time to read it in full before coming online. There was a couple of points about the paper that I wanted to discuss, and then one sort of major question. The first is there was a claim in the paper about ad transparency extending as far as identifying the people who were subject of the ad. So I wanted to say that, I mean, unless there's something new that's developed very recently, that is not the case. We do not have any ad repositories where it's possible to identify the people that view the ad. I wanted to get your opinion on transparency being formally extended that far. From my view, this is something I've been advocating for a while, because it allows the actual marketplace to develop. Because if somebody is micro-targeted with an advertisement, the other side could theoretically identify that person through anonymization, and then send an ad back to that person in the same way that we publicize ads for the purposes of political debate and electoral events. So I was wondering about your thoughts on the legal obligation of transparency being extended to the people who are the recipient of the ad, and making them identifiable in some way, not necessarily identifiable, but that process be made to be formalized. And the second, what the thoughts on that in relation to the Article 19 approach in particular, where you're not actually restricting content, but you're opening up the marketplace that allows the content to be questioned and rebutted, as opposed to removed and disengaged from. And the second approach is, in Europe, we've obviously been tackling disinformation for quite a while. There's a claim in the paper about the EU's code of practice of disinformation not having any performance indicators, and I can say that that's categorically not true. That's a mistake that needs to be addressed. There are key performance indicators in the code of practice of disinformation, and in fact, beyond the code of practice, we have forthcoming the Digital Services Act and the Digital Markets Act, and the DSA in particular is looking at regulating amplification as opposed to content. And so that the platforms would have an obligation to be, which kind of ties together with this idea of algorithmic curation and algorithmic transparency, is that rather than restricting content, that the platforms show how they de-amplified the problematic content or disinformation. So I would like to ask both the speakers their thoughts of this from a free expression point of view, and whether the de-amplification would be sufficient protection of free expression, or whether or not this would be troubling from a free expression right. And I'll turn it back over to the speakers. Thank you very much.
Thank you, and thank you for bringing those two issues to our attention. So we'll look into that question with regards to KPIs and the misinformation code of practice. But certainly it would be interesting to hear responses from our speakers on the questions that you raised, and potentially from one or both of our commenters as well. As I know you specifically referenced back to Article 19's position on this, so it might be interesting to hear from them as well. Ivar, do you want to go first?
Sure. I think at least the first one seems to be regarding or addressed to my proposal, to my paper. So there are no currently there are no ad libraries that would go so far as identifying the very person that viewed an ad, and if that's not, if somehow I made the mistake of implying that, or in the paper that it needs to be corrected. Furthermore, that is not part of what I propose. So I would not go so far as propose that companies be mandated to disclose the actual people with individual level data, the actual people that viewed certain ads, because I agree with you that would raise tremendous privacy concerns, and I think overall it would be a disproportionate restriction of privacy and data protection. So that was not part of my proposal. And again, thank you for pointing this out, and I'll review it again and make sure that it's clearer that that's not what I'm proposing, and that is not currently what ad libraries do. I think, yeah, I'll take that on, and it seems that a few of the other questions would be better addressed by not by myself.
Akriti, do you want to go ahead?
Oh, sorry, I was on mute. Thank you so much for your question and your comment, Professor Leiser, and this is extremely critical to note. I'll just start off by talking about the question of key performance indicators in the paper. And thank you so much for highlighting that. I think in terms of my assessment of the EU code on disinformation, would have tried to capture is, and maybe that's not been articulated correctly, and I'll make a note of that and sort of rectify it, but not that the code lacks key performance indicators, but based on sort of some of the literature that I've read around the review of the EU disinformation code, I think there is some view about how these key performance indicators are not specific enough. There's not enough data which is being provided to researchers, and there's no consistent or common reporting structure for monitoring and evaluating these key performance indicators. So I think that's one sort of aspect in the paper that I need to articulate more correctly. What I meant was that there are not no key KPIs, but the fact that these KPIs need to be further strengthened. And I would be looking at this more closely to understand what are the sort of problems which can be fixed in the Indian context. On the whole question of, whether self-regulatory organizations like the, social media councils, which is in the Article 19 proposal, or the hyperlocal platform communities, which I talk about, I don't necessarily think my proposal, they would be reaching a point anytime soon where they are sanctioned through a law or through a statutory code. Secondly, I also don't think right now the way that I have thought about these models, they will not be making any decisions about user speech. They will be supporting and they will be helping platforms to sort of more contextually better understand misinformation challenges, across languages, across political groups, across various domains from health to education, etc. So that's more of a supportive sort of value building role that I see for that. So as of now, I don't see an imminent free speech challenge. And with that, I hope I've answered some of your questions. Please let me know if I've missed out on a point. And thank you so much for raising this once again.
Thank you.
Barbara, did you want to address the broader question about broader approaches or impacts to freedom of expression, because that seems to be quite core to what you were mentioning earlier as well.
Yes, but I'm not sure I understood Mark's question on our model, because I didn't describe the second model which we were proposing, which is on the unbundling, because we think that should go in parallel these other regulatory models, because that addresses kind of like a reverse issue for the content removals, right? Like, content removal versus content curation, which is also very obscure and we don't know how this system works. So I'm not sure I have time to address this, but yes, so the amplification is a freedom of expression issue, obviously, from the point of diversity and pluralism, because we don't know what information is hidden from us or how it is curated and so on. So that's why we think that it's on the structure level, it needs to be addressed. But again, through the competition and ex ante measures rather than through regulatory interventions.
Art, did you want to join? I don't want to put you on the spot, but you're also welcome to join if you want to.
Yeah, sorry. I hadn't had a chance to come back and read the whole paper. But what I was saying was that in what I was trying to get across is in Europe, there seems to be more emphasis through the Code of Practice of Disinformation, the key performance indicators, and the new Digital Services Act, where the emphasis has been not so much about content removal per se, but an obligation to de-amplify. And so my question was more along the point of, do you see de-amplification as raising any more specific free expression issues, or do you think that's an acceptable common middle ground for, hey, you still have the right to speak, but that you don't get to go viral? And that comes back to kind of the concept of algorithmic transparency, that it's not the user per se that's causing the harm, it's the amplification of the content by the platforms which is actually causing the harm, and a de-amplification obligation would be an acceptable middle ground to people that that respect free expression and want to hold that right. So you're not removing content, you're simply placing an obligation on platforms to de-amplify.
Yeah, so it's definitely better than content removal, but there are still freedom of expression issues, like to what extent, what content, how it is decided. So from a algorithm, but also for deciding which type of content to remove. Then we also see some regulatory measures on the level of the state, which are ordering to must carry and de-amplify, let's say in Poland or in Mexico recently. There have been these proposals. So whether this becomes in Poland some content which is so-called propaganda of homosexuality, which needs to be amplified. So there are many, many issues when this needs to be further unpacked rather than saying that this is a better solution than removal.
Yeah, I'll just jump in. I absolutely see freedom of expression issues. There's certainly freedom of expression is engaged. I mean, part of the, the amplification is such a critical part of the expressive discourse, and that's why so many people are paying attention to it. So certainly, I think that there are issues engaged. The question of whether or not it's a proportional response or whether it's the appropriate response, the devil is in the details in terms of the harm that you're trying to combat, in terms of the specific impacts. But certainly, I think that it's problematic to view this as a way of kind of sidestepping the freedom of expression issue, because the information is still up there. It's technically, theoretically available. I mean, if nobody can see it, or if the amplification of it is significantly curtailed, yeah, I mean, certainly the analysis of freedom of expression has to take place. There's a question in the chat regarding specifically for Akriti, but I think that it's potentially relevant to both papers and to anybody that wants to jump in. The discussion around the Facebook Oversight Board and how that impacts the debate. Does that have a potential to be a model? I would love to hear certainly both Akriti and Barbara's thoughts on, obviously the Facebook Oversight Board is not a social media council. It's not what's been proposed, but potential lessons or implications from its establishment for the thinking or conceptualization around social media councils. And it may even also be relevant to Ivar's paper as well, insofar as questions about transparency and whether the platforms and the direction the platforms are moving in as far as in public engagement and transparency. So maybe we'll go to Akriti and then Barbara, and then see if our other two are interested in jumping in.
Thanks. So I definitely think the model of the Facebook Oversight Board is one example of externalizing decision-making on speech, which is what a lot of discussion is around, to have some independent review or audit of decision-making that platforms are doing. But sort of trying to differentiate it from the model that I'm trying to propose here, I feel that some of the shortcomings of the Oversight Board, and I completely appreciate that, it's not been around for too long, and, some set of decisions only came out recently, is that, it may not be specifically tailored in terms of local speech challenges to a country like India. Now, I can just imagine the kind of, speech decisions that Facebook in India has to deal with. And I imagine that only one or two might go to the Facebook Oversight Board once every year or in a quarter, or however that's going to be arranged. So in terms of that aspect of being truly focused to the domestic local context, I find that missing in the Facebook Oversight Board as of now. The second thing is, since the model that I'm thinking about is more from a standard setting, supporting development of policies, I found that the core functioning of the Oversight Board may not be as relevant to the model I propose, but certainly some values are worth thinking about, which is the election of the members of the Facebook Oversight Board. They had a fairly long drawn out election process, and there's one member from India. This is one example of an elected body in that sense, which some of the lessons can be applied to the model that I'm proposing. Yeah, these are just some of the factors that I thought about.
Barbara, did you want to jump in?
I was just wondering whether you were going to say something or whether I should say. So yes, so whether Facebook Oversight Board is a social media council, so well, yes and no. I mean, how it works in the future, it might develop that way or can be kind of interesting case study on creation, but it's definitely not independent. The jurisdiction of the council is a problem. It's also the decision making of what sort of the cases it will take is a problem, and then also obviously diversity and composition of the system is a problem. But I think that I think much more interesting examples to follow with the blue sky model of Twitter, which kind of gets less attention, but it's definitely something to watch and follow, and we are watching very closely because it goes hand in hand with these other issues which I mentioned of an unbundling, and it's kind of sort of a mirror model to the social media councils or oversight models of any sort. And actually, it was in previous commentator mentioned DSA in the EU system, the Digital Services Act, which is going to deal with some of these issues, but complementary to it is the Digital Markets Act, which is actually even much more important. And I think the companies will be freaking out more about that because DSA is kind of entrenching what they are already doing and gonna give those dominant platforms even more power and more compliance. So I think that when we talk about these regulatory solutions, we really need to link it to this business model and to the market control or market domination and deal with that hand in hand as well, because that's gonna be even bigger issue. So Facebook Social Media Council can go only so far. It's not going to resolve the major problem, which is there with the Facebook, which is not solely content moderation of disinformation.
Yeah, it's such a good point as regards to market domination and the fundamental business model, and it's challenging because these issues are all they're very conceptually distinct insofar as they address different aspects of the problem. But they're very much intertwined with one another. Questions about market dominance, questions about the surveillance economy, questions about the incentivization structure, the platform of the ecosystem that platforms are currently operating in, and you almost need a grand unifying theory of platform regulation to really tackle all these different elements, and it's very difficult to advance conversations of one without bringing these others in. Ivar or
Michael,
yes.
I could jump in on the Facebook Oversight Board. So there's been part of the criticism is that Facebook set what the Oversight Board actually is and its authority to review content and policies. And obviously, there's a sense in which it only chose those because he thought that was those parameters were in their interest. And but there's a specific aspect that I wanted to call out, that is the openness of the, let's say, adjudication of the Oversight Board. And we would expect more openness, I think, both in terms of what the content that's being discussed is, which we don't know currently from the Facebook Oversight Board. And we at InternetLab have submitted 2 comments, both on the Brazilian Instagram case on breast cancer awareness and the political leaders / Trump ban case. And there's a remarkable difference in what we were able to offer as comments, because in the first one, we didn't even have the post itself. It's not that we didn't know who the user was. We didn't actually have the text of the images of the content at issue there. And that seems to be a question that's tied to how Facebook sees this and how the interest that Facebook has here in preventing what they see as an impairment to user experience if users were required to have their content open when they appeal to the oversight board. I think that might be a legitimate question, but the fact that Facebook the Facebook oversight board lets us leads us to question that, and in particular because even if it's a dilemma, I think we would generally favor openness and, let's say, open justice, if this is what we're talking about. So that specific question, the openness of the oversight board, seems to be an important question in distincting that from what Akriti was suggesting and from the work by Artur.
Yeah, I remember when they were first setting this up, or at least in early days, Jack Balkin referred to the oversight board as he said it was the Potemkin village was the term that he threw out, where, I mean, it's this wonderful, interesting process with, esteemed and brilliant experts from around the world that'll handle this like tiny subset of the, millions and millions of content decisions that Facebook's dealing with. More than it, but then the question then becomes, yes, it starts that's what we're seeing. But these processes can also take on a life of their own, and it's interesting to see where it's going to go from there. And that doesn't, even though that's sort of it in its establishment, it could morph into something more interesting. And that's sort of why I think one of the most interesting areas to watch right now is Facebook's responses to these oversight board decisions that are coming out, and how are they reacting to it? And is it like, okay, great, we'll put up this one piece of content and nothing else will change, or are there actual indications that Facebook is utilizing both the resource of having these experts around and the deniability of having these experts, pushing them in particular decision-making directions, and using that or taking advantage of that as an avenue to push policy in one direction or another. And so that's one of the really interesting areas to watch. And I think that takes us to another very interesting question that I think underlies both of these papers, which is, the degree to which the platform's own attitude in this space impacts behavior or planning on this space. Sorry, Barbara, did you want to go ahead before I move on?
No, I just wanted to make one more comment, which we haven't addressed, but it's actually quite crucial for the discussion here, which is the difference between illegal content and content which barely violates the platform's policies, right? These are two different issues, right? And to a certain extent, some of this also falls on disinformation. And as we see, because from human rights perspective, illegal content should not be decisions of the platforms, right? The decision of independent adjudicatory bodies or courts and so on. And there is even discussion of creating some sort of e-courts of Justice Spano, who is the justice of the European Court of Human Rights, who put forward this idea, and it was elaborated by the Transatlantic Working Group, where I was a member. So if people like to kind of look at this, I recommend that. But these are important differentiations, right? So illegal content for the courts and for the platforms is only for the content which violates the community guidelines, which can be different from what is illegal, right? Like, nudity is not illegal in many settings, but Facebook is fine to prohibit it on there. So these are the two key issues also from the point of the composition of these adjudicatory bodies, or these bodies which are going to be set, but also to the top of it, there is also this push now from the states to prohibit the platform certain removal, right? So I mentioned the Poland example when this was the reaction to Trump's removal of the account, which would be a new legislation prohibited platform from removing certain content, or in Mexico and so on. So must carry obligations, But we also see this in some court decisions where the courts actually order platforms to reinstitute certain content. And it's not just a content which would be removed because, I don't know, harm reduction content which was removed in Poland, but this is also removal of extremely problematic content. They are ordered to put back, right? So an example of this would be in Italy, reinstitutions of account of Casa Pound and Forza Nuovo, which are fascistic parties, and a lot of what they put is hatred towards minorities. A lot of it is disinformation or official or manipulated disinformation. So my question would be to Akriti and also to Ivar, obviously like to Ivar to a lesser extent, but if the kind of trend of some of those governments which don't like their content to be taken down because of it will be disinformation, right? How would you square it with this kind of courts? Because the courts are also subject to capture. So let's say in Polish courts, I would not sort of think that they would, I mean, I know what kind of content they would order the platforms to put back, right? So homophobic content and so on. And a lot of it is really kind of false. It was saying that this choice, being homosexual is a choice, or, you know, you can have these conversion therapies and all of that. And it's just kind of established practice. It's not true. So how would you square it with this kind of trend? Or, but it's not a problem in India. I don't know the context in India so much, but also with the transparency, because the trends are much more complex than what basically bad platforms decisions.
Yeah, Art put in the chat that Brazil has similar proposals. Texas has a law that they're proposing now, doing the exact same thing, which is, although flagrantly unconstitutional. So it's pure performative that they're suggesting it. Yeah. But yeah, why don't we hear from Akriti and then Ivar on their responses to that challenge.
Yeah, thank you so much for pointing that out, because India is also in a very similar boat right now. And, you know, while I mentioned that there are these rules around intermediary guidelines in India, we also have governing IT legislation, which still allows government, you know, the executive arm of the government to order content, you know, take down or suspension of certain accounts. And we've been seeing this also almost now every week, as Art said in Brazil, it's happening now in India as well, in a different way, in that the government is ordering, you know, Twitter account suspensions, which have been very vocal about a recent, you know, protest against farmers for the agricultural bills. And, you know, sort of now that movement has gained momentum, and there are a lot of people opposing these laws. So from that context, we see a lot of action from the executive arm of the government in directing platforms like Twitter to not only restrict certain content, but also suspend these Twitter accounts. And what makes this situation much worse now is the IT rules which were notified, you know, 10 days ago, the amendments to the intermediary guidelines, which essentially contain two very specific proposals, and which are now going to be enacted on how the government and, you know, certain committees of the executive arm of the government can direct a platform to restrict access to content based on very vague criteria. It's not just illegality. It's you know, there's, you know, a word which says morality and, you know, public order. Now, these are very subjective assessments, and, you know, potentially unconstitutional as well, because platforms, you know, and you know, the most interesting part is that these obligations, you know, which have vague content restriction, vague definitions for content restrictions, and also an obligation for platforms to proactively monitor for certain content, which is not just unlawful, but also sort of, you know, adhering to these vague standards. What is most interesting is that these obligations are contingent on the safe harbor that, you know, these platforms enjoy. So essentially, the vague standards will be, you know, there will be a situation where platforms will be forced to self-censor and remove content, you know, to ensure that they still enjoy the safe harbor. So here, I think the problem right now more is about the executive directions to platforms, and that's an ongoing issue.
So this is I think a key point that was raised, and it's especially relevant now given and by now I mean the last 3 months in countries such as the US, but in Brazil as well, not only because, as Art pointed out, we have draft legislation trying to curtail the censorship powers of these digital platforms, but also because the outright in Brazil in the last 3-4 months has been criticizing digital platforms, arguing over censorship very often. Now, there's a saying in Brazil that if Bolsonaro and the outright in Brazil are fighting on the one side and the digital platforms are fighting on the other side, I am rooting for the fight. In other words, I think it could be useful as a push for us to review not only the amount of power that digital platforms have held, but also the amount of power in terms of defining the limits of speech that governments have forced into their hands with command and control legislation. So even if this push is coming partly from the outright, which again, I despise, I think that the best thing that we could do is make good use of it in terms of coming up with solutions that force companies to respect due process. Now, how you do this will vary greatly depending on the constitutional law framework and private law framework in any given country. What's interesting about Brazilian constitutional law is that for us, and this is not debated in scholarship or jurisprudence, this is let's say this is a unanimous point in Brazilian constitutional law. Fundamental rights bind private parties and not just the state. Now, how this will play out in a given specific case, of course, again, is up for grabs at this point regarding private platforms. But I will name just one case from 15 years ago from our Supreme Court, where there was a private association of musicians, and one of the musicians was excluded from this association. Again, a private association. Now, he went to court claiming that this exclusion was unlawful because he was not given due process rights. And our Supreme Court actually said that he was right. And because under the Brazilian Constitution, the fundamental rights bind private entities as well, that he did have a legitimate claim of due process before being excluded from a private organization. And I think this fits like a glove to the type of situation where users nowadays in Brazil, as elsewhere, are excluded without due process from private platforms. So I think clearly this is a very complex issue, but it's certainly the issue of the day, not only in Brazil, many other countries, regarding what kind of pushback we can muster against over censorship by private platforms.
Yeah, we are just about at 12:30, so I think we need to wrap that up there. But thank you. I think that's an excellent closing thought to bear in mind as we consider these issues going forward. Thanks very much to our two authors and to our two commenters. I enjoyed the conversation immensely, and I think it was fascinating. So thank you all, and hope to see some or all of you at our launch events on Wednesday and Friday as well. Take care.